This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight we're talking about workers' compensation. What do the areas of manufacturing, transportation, and construction all have in common? Well, those are the industrial sectors that are most affected by workplace injuries. So some of those injuries can be really severe. Some can affect a person's quality of life, but also their ability to work again. If something like this happens to you or a loved one, do you know how to qualify for workers' compensation? Do you know if the company they're working for even has workers' comp, or which kinds of employers have to have it? We'll talk through making a claim. We'll talk about what to do if your employer is making it difficult for you to file a claim, whether you need to talk to a lawyer about it. The 31 Law Call number, 256-536-0077. You can call in a question. You can call in live on the air. You can also text to that same number, and we will have some of your text questions tonight. You can also email questions. You can email any legal question any day of the week. You send it to lawcall@waytv.com. And when we get to a show that's on point, we pull some out. We'll have some of your workers' comp questions tonight. Michael Timberlake and William Meservey are here from Timberlake, League & Brooks. Good to have you here.
It's great to be here.
Glad to be here, Sharon.
This is the kind of cases that you guys handle. You handle all kinds of personal injury cases. That can be car crashes. It can be medical malpractice. It can also be workers' comp. We like to pull out a video and get you started with a video. You make the law call. We've got some video tonight from YouTube. So this is a typical workplace. All right, watch out for the guy that's here texting. He's not looking where he's going, and neither are the employees looking at what he's doing, and nobody stops him from falling through this hole. Thank goodness he doesn't fall as far as you would have expected. Thank goodness he lands on these boxes. Something like that going on, though. I mean, it's hard to tell whether he's an employee or whether he's a customer coming into this space. When you see something like that, first off, thank goodness he's not more hurt than he is. What do you think about that when you're seeing that kind of injury?
Well, you know, the main thing that comes to everybody's mind is that, you know, everybody's got to be aware of their surroundings and the circumstances that they're getting into. And to the extent that you participate in something that takes your mind off the ball.
Texting while you're walking?
You know, those are the most difficult types of cases that we see. And in Alabama, we're a pure contributory negligence state, which means if you contribute to your own injuries in any way, shape, or form, then it is a bar from recovery. So if he's on the premises as a guest or a business person there, you know, it's going to be a tough case because he contributed to the injuries, and the condition that caused his injury should have been open and obvious to him under that situation. But if he's an employee, it could be something different.
Yeah, you could certainly be entitled to workers' compensation. You know, it would, in a workers' compensation setting, you're not going to have to prove the employer's at fault. All right, it's a compromise, and the compromise is that in exchange for not having pain and suffering and mental anguish and some of the things you typically see in an injury case, workers' comp, you don't have to prove the employer's at fault. If you're hurt on the job, as long as it's not through, you know, horseplay or a violation of a safety rule or something along those lines, you're going to be covered in that situation. That being said, you're going to be limited to essentially medical treatment as it relates to that particular injury. You're going to be entitled to temporary total disability if the authorized treating physician pulls you out of work, and you'll be entitled to some sum of money if you have permanent partial or permanent total disability. But the first thing I see when I see that video is, thank goodness for OSHA.
Yeah.
Right?
Exactly.
I mean, this is a video I think takes place in a different country. You know, and even I was in a big box store earlier today.
Yeah.
And someone had to get on a forklift. Well, they've got these things that go across the aisles. They make sure the aisle's clear. They make sure no one's out there.
Probably somebody with flags, right, and beeping and things like that.
And but that's going to all stem from, you know, the laws that we have in this country that allow a person to pursue those type of injury cases where someone was negligent.
Yeah, I mean, the biggest thing is that comp is not fault-based. So basically, if you had an injury that was related to your employment, you're going to get limited benefits, but it's going to be something.
Okay. Folks don't necessarily get rich off workers' comp cases, right?
You'd much rather not be injured than have a comp case in Alabama.
Okay. Another thing that we want to talk about, you know, we like to talk about whatever legal things are in the news, and what's in the news this week has been the McDonald's and the Quarter Pounder situation, and people getting sick off of some ingredient in there, whether it's the onions or so E. coli, listeria, those kind of things. When somebody's injured from eating something from a restaurant, what are there going to be class action suits for this? Or if somebody in Alabama had been injured, how would they proceed with a problem like this?
I mean, this is just kind of getting off the ground in terms of the legal standpoint. There was like 60 people in about 10 states that had suffered some ill adverse effects after eating Quarter Pounders. And so they're trying at this point to trace it back either to the meat in the Quarter Pounders or potentially the onions. The ailments were either listeria and or E. coli poisoning. So these are all kinds of things that people need to be on the lookout for if you've had an ill adverse effect after eating at McDonald's. Now there are a couple lawsuits that have already been filed.
There are, and there'll be class action lawsuits. And so if there's someone who has suffered listeria or E. coli or one of those as a result of having eaten that, then they may have a potential to join a claim. But there's going to be some things you need, right? You're going to need to show that you had that Quarter Pounder. So you're going to need a receipt or some sort of, a history from the app. A lot of people order McDonald's from the app, right? So it's on your phone. But you're going to need some sort of proof that you were there. You can't just submit your name.
Yeah.
And you're going to need injury, right?
Yeah, you got to have, and you're going to have some medical evidence that this, whatever your ailment was connected to that. So there's some things to do, and that's why it's important to know about these things, as soon as possible after they happen.
Okay. And one of the interesting things about that, though, is food poisoning cases, where someone just goes to a restaurant and through ill-prepared food gets sick, can be very difficult cases to prove. There's not the evidence rarely gets preserved. You don't have access to the kitchen to take pictures of the chicken left out on the counter or whatever it is. And so one of the few times where lawyers can prove these food poisoning cases is where there's an outbreak, right? And the same can be true for a MRSA case at a hospital.
Right. Okay. Yeah. More than one, and in this case, there's 60 in 10 states, so it's pretty serious. But that's what leads. That's kind of one of the building blocks that we can look at.
Because otherwise, you're going to think, how do we know it wasn't at your own home, right? Your own kitchen, your own cooking.
Sure.
Okay. Call in your questions, the 31 Law Call number, 256-536-0077. Talk to us a little bit about what filing for workers' comp is like. So if you're hurt on the job, what do you need to do?
Well, first thing you need to do is report the injury, because that's one of the critical things that you need to do. You need to report it to your supervisor, you need to alert them that you were injured, and you need to ask to go to a physician that they will appoint for you to have your injury assessed. Those are the critical things. If you don't report the injury, it can be fatal to your claim.
Absolutely, and of note is in Alabama, you have 5 days to report your injury. So you can't have constructive notice. If you were hauled off from your workplace in an ambulance, your employer should be on constructive notice that you were injured. But if you hurt your back and you don't tell anyone and you work through your shift, that's a situation where you can tough it out, and all you're going to do is just wiggle your way out of whatever potential benefits you might have had. And so you always want to make sure you report those injuries, even if you're not sure you need medical treatment yet.
We got this email question from Rick. Rick says, how can I afford to pay a comp lawyer when I'm already missing work and I'm hurting for cash? Okay, how does he get a lawyer?
Yeah, it's a good question. One of the things you need to know about workers' compensation is that if it is a compensable injury, your employer is obligated to pay you for the time that you're off work. So after the first 3 days, they're obligated to pay you 2/3 of your average weekly wage for the time period that you're off work. And that goes until the physician sends you back to work. So, there should be some money coming in after your injury. But of course, you don't have to pay a lawyer up front in these cases.
Lawyers that handle these types of cases like we do, we work on a contingency fee, which means we're only paid when we recover money for you. So we get paid out of the money that we recover for you. It's a percentage of what's recovered in workers' comp. It's 15%. And that fee is governed by our Workers' Compensation Act, the statute. So workers' comp's not like getting injured any other way, where we follow common law and what have judges done in the past and the precedent set. We're following strict statutory codified law out of Montgomery, all right? And so there are a lot of very strict and archaic rules that we have to follow because, our Workers' Compensation Act hasn't been updated since the late 70s. So,
yeah, I mean, the main thing people need to know is that the structure is similar to other states in Alabama because all comp is the same. But Alabama's workers' compensation benefits that are provided have not been increased since, 78?
Yeah.
And you're still capped at a very, very low rate. So, even if you've suffered a total disability or a partial disability, you're not going to get enough to get you through.
If somebody's worried that their boss is going to be upset with them that they file, right? Because they're costing their company, are they costing their company money? People are liable to be afraid that they say something and they might get fired or they might get punished some way.
Well, workers' comp is an insurance, okay? If a company has more than 5 employees, they're required to have it. And they either have to self-insure or they have to purchase an insurance policy, very similar to what someone might have on their automobile, right? They purchase a policy from over here, and if I'm not paying attention and I rear end someone at a stop sign, they're not going to have a lot of direct communication with me.
Okay.
They're going to have a lot of communication with my insurance company that's going to call them, it's going to, ask for their estimates and do all these different things and get them fixed up. Well, it's sort of a similar situation here. This company has purchased insurance, and the employee's not really going to be dealing with their employer. On this particular issue. They're going to be dealing with the insurance company. Sometimes the employer knows what's going on, sometimes they don't, right? But in theory, a workers' compensation claim is going to raise the premium of an employer.
Okay.
All right, so employers don't like them because it can raise their premium. They could get canceled, just like if you had 5 wrecks in a year, your auto insurance company might say, you know what? I don't want to insure you on the roads anymore.
Yeah, jack up the price.
Same thing here. If you've got 5 workers' compensation claims in the same year and don't have a good reason why, that company may be at risk of losing their insurance or paying some exuberant rate.
Okay. We're going to take a break. Be right back, answering more of your questions about workers' comp. Stay with us.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Meservey. And hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. Tonight we're talking about workers' compensation. If you've been hurt on the job or a family member has, call in your questions. The 31 Law Call number, 536-0077. You can also text to that number. You can also email us at lawcall@waytv.com. William Meservey, Michael Timberlake here from Timberlake, League & Brooks. Talk to us a little bit about the doctors that you're going to see. So if you're doing a workers' comp case, do you go to your regular family doctor, or do they make a report for you? How does it work?
Well, I mean, that's kind of the first thing that you're going to do after you report the injury and you ask for medical treatment. They're going to assign you an approved treating physician.
Okay.
Large corporations typically have like an occupational health doctor that's on that they use on a regular basis for this type of thing. Other employees may send you to the emergency room if it's that significant. But anyway, the initial doctor that is going to be assigned is going to be the doctor that's going to be the one that controls your medical care throughout the course of your treatment. Now, the employer gets to appoint the medical doctor, but they don't get to basically say what the medical doctor can and cannot prescribe under that situation. If you're not satisfied at some point, you can change, but that's not anything you want to do a lot.
No, and to just build off that, you're really only going to have an authorized treating physician if you make it out of that occupational health or urgent care setting, right? So if it's a situation where you get a stitch or two, and they go and they take the stitch or two out, What we're talking about with an authorized treating physician is when you have a serious injury, one that requires special care, like an orthopedic or a neurologist or something along those lines, right? And let's say you do get into that orthopedic physician and you treat with him for a period of months, and he says, you know what, I think you're all better. Let me get you back off to work. And you're saying, but my knee still hurts. My knee still hurts. Do you have any options at that point? And you do have an option. You've got one ace up your sleeve. You can ask for a second opinion.
Okay.
And they have to provide you a panel of 4 doctors, and you get to choose one of the 4 off the list. They will then send that doctor all your medical records, and that doctor has to agree to take you on as a patient. So there is a chance and an opportunity to do it, but you kind of want to hold that ace up your sleeve until you really need it, because if you burn it early on, you don't get another one.
And you're going to be stuck with somebody, you know, in that situation.
Mm-hmm.
We've got Dory on the line with a question from Huntsville. Hi, Dory. Thanks for calling. What's your question tonight? Hey, Dory. Thanks for calling. What's your question tonight?
Yeah. Are you talking? You can hear me?
Yes, ma'am. Thanks for calling.
Okay. I'm sorry.
Sure.
Okay. I'm calling because I was I was fired from my last job. But just before I was fired, I had filed a claim for an injury I sustained there.
Okay.
And so, of course, they had no choice but to follow through with it. So I had, long story short, I had 2 surgeries, a lot of healing time in between. I haven't had a job since. This was back in November. My question mainly is, because the doctors and another attorney I had spoken with had told me that if I'm going to get another job, then the workman's comp is going to want me to be done with them. Okay?
Okay.
So, and the doctor told me that as well. Okay. And so I haven't had another job. I haven't had any income since the day I was fired back in November.
Wow.
Yeah. So,
Right. I mean, there are some protections here.
There are, and I think it's helpful to sort of explain the stages of workers' comp and lay those out. So, you know, you get injured, and then you enter into medical treatment, all right? And while you're receiving medical treatment, the doctor may have you out of work. You may be receiving those temporary total disability benefits. You may get to a point where the doctor thinks you can go back to light duty. You're not all the way better, but maybe light duty, right? And so at that point, he can release you to light duty, and your employer has 2 options. They can say, you know what, this light duty note from the doctor says you can't lift from floor to waist more than 20 pounds. Yeah. We've got these boxes that's part of your job to lift. So that's not something we can accommodate right now.
Okay.
So you get to stay at home treating and continue to receive those temporary total disability checks. Or if the employer says, you know what, you can't lift those boxes, but we have this other little job you can do, then they can accommodate that light duty, bring you back into the workforce while you continue to treat and go through your physical therapy or whatever it is you're going through. Then at some point you get to what's called maximum medical improvement.
Okay. As good as you're going to get.
As good as you're going to get. You're either all the way better or you're as good as you're going to get. And at that point, if you had a serious enough injury that you have a physical impairment, a permanent restriction, okay, or the doctor says, you know what, you can lift that 20-pound box from the floor to your waist, but only occasionally, a couple times a day, tops.
Okay.
Well, at that point, your employer can say, we can't meet those restrictions, and so we're going to let you go.
And that's okay. They can do that?
Perfectly legal in the state of Alabama. It's an at-will employment state. So, you know, they can't do that when the doctor says light duty.
Okay.
But they can do that when the doctor says maximum medical improvement, or MMI as we call it sometimes. And so Alabama really only gives you one protection in this state. You cannot be fired for having filed or maintained a workers' compensation action. But the ominous is on you to prove it.
Okay.
That you were terminated for that reason. It's extremely difficult to do because they're never going to say, yeah, you filed that workers' compensation claim 9 months ago and we're just going to have to let you go. They're going to say, you know what, you were late for the 3rd time coming back from lunch, and that's a fireable offense, and we're so sorry, we're going to let you go. Okay. And so sometimes there are, you know, on paper it's one thing, but in reality, sometimes we can pursue those cases, sometimes we can't, and it boils down to, can we prove your case? or not. And so it's worth exploring, and give us a call and let's see if we can get to the bottom of it.
There's some protections there, but it's a tight window. You got to prove that you were fired solely because you filed or maintained a comp claim and not for some other kind of reason, which, depending upon what your work circumstances are, can be hard to prove at some point in time.
How about your next employer? So when you're filling out applications for your next job, do you have to tell them that you had a workers' comp situation before or that you got hurt before?
Well, you need to be honest on all circumstances.
Okay.
If you didn't, I'll just say this. If you don't tell your employer that you've had a prior injury or what prior injury is, and then you go onto that job and you suffer reoccurrence of that injury, your next employer may not have to pay workers' comp.
Okay, wow. And can they ask you, future employers, can they ask you what your health situation is? Is that a protected thing?
They can ask you about your physical ability to do a job.
Okay.
They can't necessarily ask you, are you pregnant? They can't do that.
Right.
But they can ask basic questions about your physical ability to perform certain tasks.
Gotcha. We got this email question from Brian. Brian says, am I able to pursue workers' comp benefits even though I'm no longer working at the job I was working at when I got injured?
Yeah, so it depends, right? Did you report it?
Okay.
Did you have a pending workers' compensation claim? Just because you get terminated or you quit your job doesn't mean that there's still not workers' comp if you've got a case pending, right? And on top of that, workers' comp covers medical treatment related to that particular injury for life.
Okay.
As long as you don't waive that as part of a settlement agreement, right? And so, it can be a situation where you're on your 7th employer and that other employer from 7 jobs ago is still paying for your annual neck treatment or whatever it may be. And so those situations do arise. But if there's a situation where you didn't report an injury and you didn't do it within that statutory period, then they're going to have a pretty good denial on that particular claim.
And if you haven't established that it's a compensable claim, that can be hard as well, because you only have 2 years to file a workers' compensation claim after you're injured to make sure that you have that claim in place typically. So there's a way to extend it, but really you want to make sure that within a 2-year period you understand whether they've deemed it to be a compensable injury or not, and what your benefits are going to be.
We're going to take a break. Be right back answering more of your questions. Stay with us. If you didn't get your questions answered tonight, here's how to get in touch with Michael Timberlake and William Meservey with Timberlake, League, and Brooks in Huntsville. The number is 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And Sharon is a family law attorney. She practices in North Alabama. She does a great job with child custody, divorce, child care modification, things like that. 256-539-7337 or SharonFamilyLaw.com.
Thanks for all your calls and questions tonight. We will see you next week.
Have a great night.